Hello, everyone. My name is Lisa Honka, and I have a company called Your Key to Senior Living Options. During this pandemic, we have been interviewing some great experts on different things from mental health to how to get your finances in order, as well as we're going to be interviewing today Ed Soulsby and Mary Trotter. So we're really excited about having them on our show today. Just a couple housekeeping items. Please, everyone, turn off your cell phone so that we won't be interrupted. And if you do not want to be seen on this Zoom call, you certainly can go to the right corner of your screen and stop video so we won't see you at home. At the bottom of your screen, there's also a opportunity to send an email to us, a text message. So if you have any questions during this presentation, you can certainly send us a message and we will answer your questions. And then at the end of this presentation, Ed and Mary will also answer your questions. So we're so grateful for their expertise. You have been here in the Villages a very long time. Your reputation is stellar, absolutely stellar. So we're so happy to be with you today. And I'd like you just to give us a quick overview of you and your practice, and then we'll get right into the presentation on what paperwork people might need if they're moving to a assisted living, independent living. So go ahead, give us an interview, and again, just give us an overview of who you are and your practice and what we're going to be talking about today.
My name is Mary Trotter, and this is my partner, Ed Soulsby. Ed and I are board certified elder law attorneys. There are only about 105 board certified elder law attorneys in the state of Florida, and Ed and I are two of them. We're the only ones in this area. An elder law attorney is an attorney that specializes in those areas of law that are of most concern to people 55 years of age or older. Well, the Florida Bar thinks 55 is elderly. I'm not quite so sure about that. So we do wills, trust, probate, trust administration, but we also do guardianship and public benefits, and we are also both VA accredited. Today, we're going to be talking about legal preparation for entering assisted living and nursing homes. So the two most important documents to have when you enter a nursing home or assisted living is a power of attorney and a healthcare surrogate. Excuse me. A power of attorney grants authority to an agent to act in the place of the principal. They can pay your bills, do your banking, sign contracts, apply for public benefits, and hire an attorney to represent you. They can also prevent a guardianship proceeding. You do not want the court to take control of your assets. You want someone that you trust.
So why avoid a guardianship? Well, it can be time consuming. It is expensive. And the person being appointed may be someone who doesn't know the incapacitated person. So you always want to be in charge of who you want handling your affairs. I know Mary has seen a number of horror stories over the years in terms of judges appointing their friends to handle the affairs of someone. And that's not a place where anyone wants to be. So you want to be able to have someone in place. But what is guardianship in and of itself? Well, it's the legal process to protect and exercise the legal rights of persons when they are incapacitated. And there are three types of guardianships. There could be the guardian of the person, where we're just looking to take care of them and make sure they're attended to. Or it can be the guardian of the person's property, so that we're managing their business and making sure their bills are paid and no assets are being lost or wasted. And of course, it's a combination of both, a guardian of the person and the property. Well, in terms of the actual guardianship process, a petition is filed to determine that person's incapacity and whether they in fact need a guardian to be appointed. And the court will appoint an attorney for the person who's deemed or alleged to be incapacitated. The court will also appoint a 3-member examining committee to evaluate the alleged incapacitated person and to file a report with the court. And based on their reports, the court will then address whether, in fact, a guardianship is needed. And if necessary, the court will appoint the guardian. Then once the guardian is appointed, then they have some duties with the court in terms of annual reporting requirements, managing the assets of the incapacitated person, and making sure that their residential setting and their medical and social needs are being met. And so that's the guardianship process. So our goal is for you to be in a position to avoid guardianship. So that's where a power of attorney comes in handy, because it is a very powerful document that you name someone to act for you, but it's considered a less restrictive alternative to guardianship. However, it can be set aside by a court.
The reason that we're stressing powers of attorney is that during the lockdowns that we have experienced, powers of attorney were urgently needed. And the people that didn't have them were in trouble. We had difficulty handling people's IRA distributions. We also had difficulty changing any type of financial interest or even renewing CDs, because if they roll over at a lower rate. So a power of attorney was very important, and we really began to understand the great importance of it during this last year and a half. However, it can be set aside by a court. So my suggestion is to have a living trust if you're really concerned about it, because the two working together are very strong protection. Because although a court can set aside a power of attorney, it cannot so easily set aside a trust. However, you need to be sure that your trust is written correctly and that it waives court-ordered invasion of principle. Because if it does not waive court-ordered invasion of principle, a judge can come along, take everything out of your trust, and put it into the hands of a court-appointed guardian. Mm-hmm. I don't know if any of you watching like Stephen King and scary movies. If you do, Google the following: guardianship abuse in Florida, and you will begin to see why we stress the importance of avoiding it if possible. Mm-hmm. AARP has several very good articles about guardianship, and so does the New Yorker magazine, although those are on a national basis.
So with respect to the power of attorney, there were some changes implemented a few years ago. And so your agent, when acting, has a duty to preserve the principal's estate plan, a duty to keep accurate records, and a duty to act loyally for the sole benefit of the person who created the power of attorney. Now, in Florida, unfortunately, we have a very comprehensive power of attorney. The word all is not effective in Florida. We have to be very specific with the powers you are delegating to your agent. So there are no blanket or default powers. We have to identify each and every power that we want your agent to be able to act for you. Because remember, with the power of attorney that you're delegating to the person to act for you, they have immediate ability to act. You still have the right to act for yourself, but they can still act for you even if you're perfectly fine. So it is a very powerful document. And you want to make sure that the person you elect to act for you has, you have great faith, trust, and confidence in them that they're going to do the right thing for you and in your best interests.
It is always a good time before you go into assisted living or a nursing home to have all of your estate planning documents reviewed: your will, your trust, your power of attorney, your healthcare surrogate. We often find that older powers of attorney do not work, or out-of-state powers of attorney do not work. People simply do not accept them. It is also important that your power of attorney has all the powers that you need. And Florida requires certain powers to actually be initialed in order to have them. One of the powers that is very important is the power to create trust. If for some reason your money runs out and you do need public benefits or VA, you may need to create an income trust, especially for Medicaid. And that has to be specifically mentioned in the document. A wife or husband can do it for their spouse, but a child cannot without it being mentioned in the power of attorney or without a guardianship proceeding. You also should have the power to change beneficiaries. Under a power of attorney, your agent has a fiduciary duty to preserve your estate plan. So they can't go around and put themselves as the beneficiary of all your accounts. That would be breaching their fiduciary duty, and that could be set aside. But they may need to move an account. And if they're unable to change or put on a beneficiary, they will not be able to move an account. Also, the power to disclaim is very important. We use those a lot in probate. We also use them in tax planning. That's when you say you don't want something. Often people will inherit property, that the value of the property is not, it's less than the mortgage. And you really don't want that. Or you especially don't want to win a trip to Hawaii when you can't go on it, and you don't want to pay the taxes on it. Also, you need to be sure that your power of attorney allows your agent, especially if that agent is a spouse or a child, that they can act in their own self-interest. Because there are times we may need to transfer money between spouses or for some reason transfer it to a child.
Yeah, and when we want to do it with the transfer of child, what Mary's describing is not making a gift to the child.
No.
It's more of a compensation arrangement for personal care services. So that's why we want to have that particular power in the power of attorney.
Although Medicaid law does allow you to transfer to a disabled child without penalty.
It does. I think we're a little behind on the slides.
We are. We need to go to health
If you
care.
can jump over to page 12 there, Maureen.
There we are.
Perfect. So one of the other documents in addition to the power of attorney you have is your advanced healthcare directives, and one of which is a healthcare surrogate. And this allows a person to appoint someone to make healthcare decisions for them if he or she is no longer able to communicate with healthcare providers. The idea is that you want someone that you have trust in, that they're going to make the right decisions for you when you're not in a position to do so yourself. Now, if you don't have a healthcare surrogate, the state of Florida is so kind to give an order of priority of individuals who can act for you. And again, it may not be who you want acting for you. So if you want to slide to or move to the next slide there, Maureen, 13, there we go. So the state of Florida under Florida Statute 765.401 says if you have a court-appointed guardian or guardian advocate, they can make healthcare decisions for you. Your spouse may, a majority of your adult children, a parent, a majority of your adult siblings, an adult relative involved with your care and has had regular contact with the patient, or even a close friend. So again, I'm not so sure about you, but I know I would not want a majority of my adult siblings making healthcare decisions for me these days. So it's always good to have a healthcare surrogate in place so that you've picked the people you want making decisions for you.
And please note, the court-appointed guardian comes before the spouse.
Yeah.
What I have seen in many cases is someone's healthcare surrogate will be their child, not their husband or wife. They become mentally incapacitated and the child moves them away from their spouse.
Mm-hmm.
So you may want to consider putting your spouse and a child together, or picking the one that you would want to stay with if you did become incapacitated.
Mm-hmm. And then one of the other healthcare directives is called a living will. And this is where you declare, or the person declares their intent to have or not have life support withdrawn or withheld under certain circumstances. And your healthcare surrogate is the one who has a duty to provide the physician, at least the attending physician, a copy of that living will or the original itself, so that they're aware that if those conditions are met, that you've expressed your wishes not to have certain life-saving procedures done, or you do want certain life-saving procedures done. So let's just make sure that the physicians and the hospital providers are aware of your wishes.
The other is a do not resuscitate order.
Mm-hmm.
That is a decision that probably should be made with you and your doctor, not with your attorney. Because a do not resuscitate is a different directive than the living will. The living will prevents you from being on life support for a long period of time, while a do not resuscitate will not resuscitate you if your heart stops.
Mm-hmm. And then if I could just mention one other healthcare document, it's generally called the HIPAA privacy authorization. Generally, you want to have someone have the ability to access your private medical records when they're in a position to make medical decisions for you, because it's nothing's worse than having a family member who does not have access to medical records, but they're being told by doctors what to do, and they can't make an informed decision without that medical record information in front of them. So it's usually called an authorization to release, private health information under the HIPAA laws.
Often we will have one child as the healthcare surrogate, but we will name every child on the HIPAA release so that all of the children can find out how their parent is doing.
Mm-hmm.
So that's our talk.
So I have a few questions. So I just want to kind of go back to a couple stages in people's lives when they should have the legal papers done with you. So the first one would be when they move to Florida and they're coming from another state. That is really the moment within the 6 months of getting here. People really need to have their legal papers reviewed, make sure that that they're up to date, that they've got the right people on, and that it really is a Florida document, not a New York or New Jersey or Wisconsin document, that it's a Florida document and that it's inclusive of what needs to be in it. And then another point in time can be when either there's a status change medically, right? So one of the partners, let's say in a marriage, has been deemed incompetent, or there's been a medical change, whether they have been diagnosed with cancer, Parkinson's, Alzheimer's, ALS, right? There's a medical change, and perhaps the prognosis is that one spouse will outlive the other spouse, right? That's sort of a moment in time. Or when there's a death of a spouse, and now you need to say, well, my person that navigates for me is not in that position anymore. Who is that person going to be, or persons, right? So can you talk a little bit about those kind of stages, and if I missed any stages? Because I think sometimes we do the documents, and I meet with people and they did them 20 years ago, and things have changed. Those children that you believed in may have died, or they may have had some medical issues or financial issues that you didn't see 20 years ago. So can you kind of talk about when papers need to be drawn up and reviewed, and then how do you play into that? How do you see those time frames?
You named 3 stages of when documents should be looked at. The first one that you asked about was when you move to Florida, or when a person moves to Florida. It is important to have your will or your trust reviewed, not because may not be invalid here, but because it may be valid. Sometimes an out-of-state will not do what you want it to do in Florida. Ed had a good example of that.
Yeah, so in Florida, when we prepare wills with clients who own their homestead property, we never want to see a direction that says, at my death, sell my home, because that can open the doors to creditors who can make a claim for the interest in the home and force a sale of it. So if you come from another state, say, let's say Michigan, and we see in your will it says, at my death, direct the sale of the home, we're going to strongly urge you to update your will, because we've had that instance occur where we had someone out of state move to Florida. They had I think it was a will from New York or something like that. But in any event, the individual passed away, and the daughter came in, and she was concerned about creditors because her parent had a lot of creditors, and the will she brought in indicated sell the home. And we told her, if your parents have these creditors, you're going to have to pay them. The home's going to have to be sold. And so she was just devastated. Fortunately for her, she went back home to her parents' house and went through more papers and discovered subsequent wills that mom and dad had signed after they actually moved to Florida, and it had eliminated that sale direction on the home. So it's very important that when you do move to Florida, have your estate planning documents reviewed, because if there's a provision like that, that's a will that may be valid in Florida, but we don't want that provision in it, because that's a bad valid will. So
thank you for that. Yeah, thank you. And then other times that people would need to have things reviewed.
Okay, well, to continue on the first one, the other thing that we check on is the executor qualified to serve in Florida, because in Florida, it must be a relative or a Floridian. It can't be your out-of-state lawyer or someone like that. And also, a spouse has an absolute right to 30%. So we always make sure that that is provided for, or a postnuptial done. Mm-hmm. The second time is if we know that a spouse is going to probably end up becoming incapacitated. If they are diagnosed with senile dementia, Alzheimer's, Parkinson's, Lou Gehrig's disease, they may be or may get to the point where they can't do things for themselves. We need to prepare for the death of the well spouse. What happens to the person they're taking care of? We need to make sure that that person has an alternate agent on their power of attorney. Often, we will put a co-trustee on their living trust. so that if the well spouse passes on, there is someone that can handle things for the incapacitated spouse. So that is very important. Other times we may do a special needs will. If the person is on public benefits, the spouse can do a will where everything goes into a special needs trust for their spouse to preserve the Medicaid benefits so that that money does not count against them and knock them off Medicaid. We, many times, special needs planning is done incorrectly. It has to be done in a testamentary trust, not an inter vivos trust, which means it has to be created in probate.
Mm-hmm.
You can't have a living trust directed to a special needs trust for the spouse. And we see that mistake commonly.
Mm-hmm.
And that would not, that would disqualify the person from Medicaid. And then, of course, if there is the death of a spouse.
Correct. Or if you've named someone, a child or whomever else that you've named in your documents to act for you is no longer in a position to do so, that change in circumstance, we would definitely recommend you come in and have your documents updated.
Thank you for that. It seems sometimes easy at the outset, creating it and then living with it. But then a lot of times people don't realize, in the moment that a spouse has died or been diagnosed, that's really an important time to kind of get your life back in sort of order and figure out how to keep yourself safe. But also, again, kind of thinking as a caregiver. So I work with a lot of caregivers, and they're always worried about, protecting assets. What happens if something happens to me? What happens to my loved one? But we don't realize that 65% of the caregivers actually pass away first, right? And so at that moment that your loved one is diagnosed with something that could take a very long time to pass away from, could be a very big financial drain on the budget and assets. How do we protect everybody involved, right? The one that's been diagnosed, the caregiver, and then the adult children. How do we rope everybody in to the planning, the legal planning of the future, which is so important to protect assets, but protect needs, to provide support and safety through this journey all the way to the end. And that's a very powerful, those moments in time that we think, well, when we're 50 or 60, we'll create this and it'll last a lifetime. But things absolutely change. And it's paramount that people circle back to that document and make sure that it is intact. Do you also think that sometimes it's important to review documents every X amount of years with you, just giving you a call and saying, it's been 7 years, just wanted to sit down and talk to you? Do you advocate for that as well, as just kind of make sure everything's in order at certain times, besides, those moments in time, but chronologically too? Do you say every 7 to 10 years, come on in and let's kind of review things?
I would say 5 years.
Mm-hmm.
5 years.
I always tell my clients, call me once a year if you'd like, and I can let you know if there's been any changes in the laws.
Mm-hmm.
Laws are changing much faster. Cases are coming out much faster.
Mm-hmm.
So things are changing much more rapidly than they've ever changed before. The Secure Act of January of 2020, certain legal cases that have made certain things problematic. So it's always a good idea to review your documents every few years.
Mm-hmm. Because it's real easy once you sign your documents, as you mentioned, Lisa, that, people just put them in the safe deposit box and they're safe at home and they don't look at them ever again. And then once they realize that they have them and it's something they need to address, it may be too late because the person that needs to make the changes is no longer having the capacity to do so. And we may be stuck with certain situations that we would prefer not to be in.
Yeah, that's exactly right. A couple things that I work on with families is having the people around you, your support team, know what's in your binder, right? So everything from your photo ID, prescription drug cards, doctors, where's your legal papers? Who is your attorney, right? If suddenly your brother-in-law from Nevada comes to town and he's really your person, he needs to know what's in that legal binder in case there is a tragedy and someone's on a ventilator in the hospital. Who is that binder, and who is the attorney, and where is that information? So again, sometimes reviewing, especially here in the middle of this still pandemic, who are the people that will navigate for you, and do they know even where your legal papers are, right? How do they get to them? How do they get to the attorney? How do they connect all those dots? That's really important. Another point in time too, when I think people sometimes forget to call the attorney, is when you're selling a home, right? I find a lot of people buy multiple houses here in the villages, and perhaps maybe they've sold a house, they bought a new house, they downsized, they upsized, and when they're moving around, they also need to make sure that that home is in a trust. Is that correct? That new home?
If their first home was, yes. We always tell our clients that before you buy a new home, call us, and we can send to the title company exactly how it should be titled, rather than buy it and then inform us, because then we have to do a new deed.
Right, right. So purchasing of big assets like that, a second home or a rental, need to be, you need to know about that so that it can be put into the trust documents.
Yes, and with a rental, we have to get the mortgage company's permission.
Mhm.
Not with your home, because there is a federal law that they can put their home in. But with a rental, you do have to have the mortgage company's permission to put it in.
Thank you for that. That's good to know. Do we have any questions from the audience? I don't know. Some of the screens are dark, so it's hard to tell. Do we have any questions going forward? So I know we're going to make sure that we archive this on my website for anybody that is interested in reviewing this and looking at the slides and the presentation. Ed and Mary, how do people get in touch with you if they want to ask you some more questions, see you in your office? What is your contact information?
Well, they definitely can call our office at area code 352-205-7245, and our assistant Cindy will be glad to do the appointments. If anybody has questions about that, they want to come in and have documents reviewed, or any questions related to public benefits planning, Medicaid, so forth.
We do not charge to review out of documents, nor do we charge for an initial estate planning consultation.
Okay, great. Thank you for that. Is there anything, any other questions? Does anybody have any questions?
You can just raise your hand. I can see you on the screen. If you don't want to use the emoji or the chat, just raise your hand and I'll unmute you.
Emojis are
Emojis are fun, except if you can't figure out where it is.
The wrong one, and then it really.
There's a court case recently where the poor lawyer had some type of what is it
was
called?
A filter.
A filter where he appeared in court as a cat.
Wow.
I saw that.
Okay.
Anybody? Nobody has a question that they'd like? Okay, Angela, hold on. Angela, I'm asking you to unmute yourself. So you should
Which is
see
up
that
in the
question
right-hand.
pop up. There you go.
Okay. If someone becomes legally incompetent and everything is in a trust and the trustee is an adult child, does the estate planning that was also done through a trust go out the window? In other words, does the adult child then control all the assets until the person's death? Or does the estate planning done by the incompetent person still hold muster? Does that make sense?
Whatever was done before he became incompetent stands. The trustee has a fiduciary duty to preserve the estate plan and can only do those things he or she is allowed to do under the trust.
Okay, so, but if they change assets and sell things, or can they do any of that stuff while they have that power of the property before the death of the incompetent person?
They may have to if the incompetent person needs that money, yes.
Okay, thank you.
Mary, does it matter what kind of trust they created?
Well, usually
So that,
for estate planning purposes, irrevocable trusts are used for tax planning and Medicaid planning.
Angela, was it an irrevocable trust or a revocable
Revocable trust.
trust?
Yeah, but whether it's revocable or irrevocable, whoever the trustee is, they have a duty to the beneficiary of the trust, whether it's the grantor, the revocable, incapacitated, or if it's an irrevocable trust, who the beneficiaries are. So at the end of the day, they have a fiduciary duty to doing their job.
Okay, thank you.
Hi, Martha. Martha has a question, Maureen.
And Martha, I'm asking you to unmute. You have to unmute yourself. There you go. Go ahead. We can't hear her for some reason. For some reason, Martha, we can't hear you, even though you're unmuted. Can you put your volume up on your computer? You guys can't hear her, right?
No,
We
I'm
can-
sorry.
Okay. Unfortunately, Martha, can you?
We cannot
you
hear
go-
you now.
Yeah, Martha, can you go to the chat box at the bottom of the bar and type your question in there? And then I can read it to Mary and Ed, because we can't hear you for some reason.
If she talks slowly, I might be able to read her lips.
I didn't know you could lip read, Lisa. That's very impressive.
Oh, well, let's see if she,
She's typing. Okay, does anybody else have a question while we're waiting? Connie, Vanessa and Patrick, John, anybody?
so does everybody here have legal papers done in Florida? Yes. All right, let's see what she has to say.
I don't know if she's typing. I don't see anything coming through.
The other thing we could do is Martha can send me an email and I can also send it to Ed and Mary if she needs more time.
Yeah, everybody's going to get a link, a replay link that will come out probably in the next couple of days. And in that link will be this presentation, their handouts, and we'll include email addresses, an email contact for Ed and Mary with their phone
great.
number and whatnot, okay? So
If
then
any-
you can just,
If anyone emails me, please put your phone number in the email so I can call you back with the answer.
Okay.
It'll be days if you make me type something.
I finished my question, she said.
okay, did you hit send? Because we don't see it on here. 1 second.
The wonders of modern technology.
In the chat, if you typed it in the chat box, then just hit enter and it should,
Enter on your computer, sorry. Okay, sorry I was late. My question is, can I afford to pay $6,000 a month for memory care? Will they be allowed to take any other funds? Well, first off, I'm gonna start with Martha. Memory care doesn't always cost $6,000 a month. It can be as low as $4,000. So I guess the question is, what memory care you're looking at that's $6,000? And I think that's probably a question about how to protect assets when someone has cognitive impairment. So go ahead, Mary and Ed, do you want to speak about that? When you have a spouse who has memory loss, how do you protect assets if they need Medicaid benefits down the road, or asset protection if they need a long-term care facility?
That would be better handled in a private consultation. There are many ways to protect assets in Florida.
Yep.
There is the Medicaid waiver program that does give a small amount of money to people going to living, as well as the institution, which pays for it.
Yeah, I'll just kind of jump in here for a second. If someone were to choose a Medicaid facility for memory care, Medicaid would pay, the waiver program would pay up to $1,300 per month for their care. You would still be responsible for room and board. So your approximate cost would be about $3,000 in a Medicaid facility, in a shared male apartment for your husband. Again, Medicaid's paying for care. You still have to pay room and board. That's in a assisted living that has memory care in a shared male apartment. If someone needed to go on Medicaid and be in a long-term care facility, which we'd call a nursing home years ago, that would be a different story. And that would again be addressed by you, Ed and Mary, more closely in line with the cost analysis of that. It really is based on his monthly income, what it costs to run your house, what it costs to be there. It's a whole different scenario. And that long-term care facility is for someone who is essentially bed-bound, not someone who just has dementia, because those long-term care facilities that we're talking about, nursing homes, are not always secure neighborhoods. They're not designed for someone who's walking, talking, even though they have cognitive impairment. It's not always a secure neighborhood. It's really a long-term care bed in a nursing home or long-term care facility for someone who's bed-bound, not somebody who's walking around who has dementia. There's a difference. So we can kind of go through that again, Martha, if you want me to explain what a assisted living costs, memory care costs, what a memory care on Medicaid waiver program would cost, and what a long-term care facility would cost. But again, if you protected the assets with asset protection through Mary and Ed in a irrevocable trust, is that correct?
Medicaid protection trusts have to be done 5 years before.
Okay.
They actually protect. There are many, many ways to get public benefits, and many assets are exempt. The IRA is exempt, the home is exempt, one car over 7 years old is exempt. So it really would take hours and hours to go over all the different Medicaid options. I have a friend who is a brilliant elder law attorney, and she loves to say that Medicaid is like Baskin Robbins. There's 40 different flavors. So how we prepare one person and protect their assets, it's not how we protect another person. So it's better to go to your elder law attorney, do a complete analysis of your assets, and they can give you your various options.
And that's where a part of it really is important to have. That gives us a lot of flexibility in what we can present to a client.
Right. Can you turn your mute off, Martha, or write it in the chat? Do you want to write us another chat, Martha? No. Okay. You have to go. Okay. Okay, so I think it just, again, kind of goes back to finances. Can someone afford what for how long, right? So if you're thinking about someone who has dementia, the average life expectancy when someone finally moves to memory care in the United States is 18 months. So can you afford 18 months at $4,000 a month, 18 months at $5,500 a month, or do you need to go into a Medicaid facility? Again, we'd have to look through all of that. But a shared male apartment in memory care is about $4,500. It could be as little as $4,000 a month. So again, we have to look into all of that. It just depends how much assets you're willing to spend. What we're actually seeing now is that life expectancy because of COVID is more like 9 months in memory care. So significantly different because people are waiting so long and caregivers are getting burned out at home. So it's very sad. Any other questions about legal papers? Okay, then I think we'll probably go ahead, Martha. We cannot hear you now. Okay. All right, I think I'll circle to Martha in a little bit and we'll figure out what's going on. Okay, is there any other things you'd like to add, Mary or Ed?
We appreciate you allowing us to talk today. It was very nice.
Great. Okay. Well, we'll definitely archive this on my website, and anybody that's interested in talking to Ed and Mary will have their information on our website. We'll send you a link to this presentation as well as to their office, so you can make an appointment. And when people are making appointments, how far out are you booking now? A couple weeks, a couple months?
It's about 2 weeks, I think.
2 weeks, sometimes.
Yeah, depends on.
Okay.
Yeah.
Great. Okay, great. Okay, and if people have an emergency or families coming to town, you can kind of squeeze people in. Okay. Well, thank you again for your time. We learned a lot. And again, it's really important as life changes and situations change to have your papers reviewed every 5 years minimum, right?
Yes.
Yes.
Great. Right. Well, again, thank you so much for your time and your expertise. We really appreciate it. Thank you for taking care of all the people in the villages and surrounding areas with your expertise. We're lucky to have 2 true elder attorneys in the villages. So thank you.
No, thank you.
Have a great day, everybody.
Thank you.
You too.
Bye-bye. Bye-bye.